afternoon, everybody. My name is Graham Virgo, and this is Janet O'Sullivan, and we're going to run the next session on legal problems. Now, you've heard, we hope, just now, a little bit about what it's like to study law at Cambridge, how we have lectures in rooms like this, but we also have the supervision system, the small group teaching, where students are given work to do in preparation and then come together in small groups to discuss what they've read with an expert in the subject and with 2 or 3 other students. And what we're going to try and do in this session is to replicate the supervision experience for you. We have got a number of problems, and we'll show them on the PowerPoint, but you've also, we think, got a copy of questions as well. Good. So you can make notes on that as you wish. We may not have time to go through all of the problems, and if so, on your way back home, you may want to discuss problems with whoever you've come with, or maybe when you get home, if you're bored one evening, have a discussion about these problems and try and work out what the answer is. So, the aim of the session, as I say, is to give you an idea of what a supervision is like and try and illustrate for you what we mean when we say when you study law at Cambridge, we are in part teaching you to think like lawyers. And what exactly does that mean, to think like a lawyer? Well, you can interpret that in all sorts of different ways. But for the purpose of dealing with these legal problems, it means first looking at the facts of the problem and working out what the issues are, then working out what the relevant law is and interpreting it, then applying the law to the problem to come with an answer, and then you get a little bit more academic, perhaps, and start thinking about whether you are happy with that answer. How is the result we've reached a fair result? Is it just? And if not, why not? And if not, what can we do to change the law and improve it? And that's what we're going to try and do with you this afternoon. Now, for this session to work, we are relying on audience participation. And we're not going to be mean and pick on anybody. Just, if you want to participate, put up your hand and we will then choose you. But we would encourage all of you to participate. If you are here in an accompanying capacity, feel free to participate as well. We ran this session this morning and we got some very enthusiastic participation from people who aren't necessarily thinking about applying to read law at university. That is fine, you can all participate. Some of you may know a bit of law already, and you may want to use that when we go through these problems. Most of you won't. You will have no idea what the law is. We will help you and give you a bit of law, but don't worry if you hear other people talking about some rather technical stuff that they already know. We are not expecting any knowledge. And crucially as well, you can, within reason, say whatever you want. There isn't a right or a wrong answer to these problems. Well, that's not quite true. If you disagree with what Janet O'Sullivan and I say, you are by definition wrong. We are always right. But you may want to disagree with us because you will see quite often there are different interpretations of the law and the scenario and what we consider the right result to be. And the real point is making sure you have strong, convincing arguments to back up whatever point of view you are adopting. So that's all I want to say by way of introduction. let's go straight on to the first problem. Now, this is a problem based on a real case, a case that went all the way up to the Supreme Court late last year. So that's the top court in the country. I've changed the facts a bit and simplified them a bit, but this is essentially what the justices in the Supreme Court had to consider. Now, when you're thinking about law, you can have all sorts of different issues and different perspectives. And Janet O'Sullivan, in her problems a little bit later, are going to raise some very different sorts of issues. The issue in this problem, which I'll read out in a minute, is essentially about how we should interpret a particular word. And quite often with law, you have to think very carefully about the meaning of particular words, and that will affect the result you come to. So, this problem. Emma is a professional gambler with an exceptional memory. One evening, she went to a casino to play baccarat. This is a card game which involves betting on which of two hands has the highest score. Now, baccarat is a bit more complicated than that, but for these purposes, that's how you play it. While she was playing, Emma was able to detect small differences in the pattern on the back of some of the cards, and so could work out, without seeing the value of the card, whether it would be high or low. Emma never touched any of the cards, but she told Sam, the dealer, that she was very superstitious and she wanted him to shuffle the pack in a particular way. That way, she would know when one of the cards with a difference in the pattern was included in a hand, and so could work out whether the hand was high or low. Over the course of the evening, she won £5 million. The manager of the casino was watching Emma carefully and accused her of cheating. She denied this, saying that she was simply using her memory skills, and all reasonable people would say that she had not cheated. So the issue is whether Emma has acted dishonestly, so she should be convicted of a crime. In this country, we do have a crime of cheating, and to be guilty of that crime, you have to be dishonest. And dishonesty is a word we use a lot in the criminal law. The crime of theft and the crime of fraud depend on dishonesty. So does the crime of cheating. So the issue and the word we need to focus on is dishonesty. Do you think Emma acted dishonestly? Any thoughts on that? Yeah.
Yeah, I would say that Emma acted dishonestly. If she had not told, what was his name, Sam, that she was superstitious and that he would have to, or that she asked him to shuffle the cards in a different way, but had just stayed to her exceptional memory, I think that would probably not have made her dishonest, but the fact that she lied about being superstitious and then made him change the way that he would normally.
Okay.
Makes sense.
Okay, so you're distinguished between her memory and saying I'm superstitious and getting him to shuffle the cards in a particular way. Fine, but he didn't have to shuffle the cards in a particular way. She didn't touch them. And she basically said, and apparently this happens all the time with gamblers. They have particular practices that they feel they have to adopt just in case, if they didn't, they lost that time. So when this case was heard, it was accepted that this was fairly common, and all she was doing was saying, I want you to keep shuffling and I'll tell you when to stop. Does that make a difference, or would you still say that's dishonest?
I would still say it's dishonest because at least if we stay on the text and what it says, that she made him shuffle it so that she did it with the intention of making it easier for herself to know, to see the cards.
Okay.
And I think that intention goes beyond just what a gambler would normally do to win, because she knows that it's probably not just her luck or any fortune that she can.
Okay, fine. So that is still dishonest. Are there other views on that? Yeah.
I would argue that she's not dishonest, that she's actually not cheating, because her memory is not exactly something that you can control. So when she's asked if she's cheating, well, she's not really cheating because it's something that she does out of her mind. It's an instinct. It's not something that she's doing on purpose. So when it comes to this, I'd say she's not.
She's just using her natural skills
Exactly.
to win £5 million. Okay. I put words in your mouth, but that's the gist of it. Okay, fine. But you're saying she hasn't cheated. Okay. Anything else? Anybody else? Yeah.
I think the last couple of sentences saying that she denied this, saying she was simply using her memory skills, is that actually what she isn't actually using her memory skills. What she's doing is looking at the back of the cards, seeing whether they're high or low. And so I think that could be seen as her being dishonest, because she's not saying that she has remembered what card is what. She's just saying that she can see which one's a high or low, and therefore, because she is being dishonest, then it could be seen as dishonesty, and therefore could be.
Okay, but what if I say, and she says her skill is that she can remember that for each of the 52 cards, they won't all be marked, but for a number of them, there is a particular really small mark on the back or some defect in the printing, and she can then remember which value went with which back.
Yeah, okay, I think then that would be memory skills, but I think in this situation you have to determine what memory skills she was talking about, and therefore whether she was being dishonest.
Okay, but if it is just remembering the back of the card and remembering what the front value is that dishonest? It's not, okay. So it depends what we mean by her memory skills. Okay. Anything? Yeah.
Surely it was the job of the card company to produce a set of cards which in every single circumstance would provide a fair game for all. And in fact, it's not her fault that she had a set of cards that she could distinguish which was higher. Ultimately, it was the card company's fault.
So you're blaming the card company. Okay. So should the casino sue the card company for defective goods? Maybe. Okay. Fine. But you're saying that's not her fault, it's somebody else's fault. Okay. Yeah.
I think it also depends on what you mean by dishonesty, because right now we might be interpreting it as saying that she's consciously lying about something, but it could also mean that she actually took an action to cheat within this scenario. And if we look at the facts of the case, we could argue that actually she didn't physically act in any way to cheat him again, because she didn't touch the cards.
And she has not touched the cards at all.
And she only mentally looked at the cards, and at the same time, she only requested that Sam shuffle the cards in a particular way. Sam could have chosen not to do that.
Okay. So you suggesting not dishonest, therefore?
Yes, I am.
Okay. Yeah.
I would argue that she doesn't have to touch the cards to manipulate the cards.
So the manipulation is saying, oh, I'm superstitious, you keep shuffling until I say stop.
Basically, and I would say Sam works for the casino. So Sam is a bit dishonest.
Really? So should we get him as well? Okay. Right. So we're going to get the card company, we might get Emma, and we'll get Sam. Excellent. Any other views? Yeah.
I think the moment that she sort of changes the nature of the game so that it's no longer gambling with obviously getting him to shuffle in a particular way, so that obviously she's looking at, he's shuffling it so that she can tell where the patterns are, and the moment you change the nature of gambling so that it's no longer a game of chance, that's cheating, because
Okay. So you're saying gambling is a game of chance, and because she's using her memory skills, she's cheating.
yeah, because she eliminates the element of chance, which means that it's no longer gambling.
Okay, right. And let's have one more view. Yeah.
It's really clear at the start that she's a professional, and professionals, people have skills, like a lawyer could be particularly confident and they would perform well in court. You could argue that she's the exact same, she's a gambler, and she's particularly confident in her memory, so you can't penalise her for that.
So does that mean we would expect a higher standard of behaviour for her as a professional than if it was me gambling? So if I happen to do this, I'm fine, but she is guilty, which may be a valid distinction to draw. Okay, I do want to ask one more question. We've been skirting around the notion of dishonesty, and obviously that's what this is about. When we assess dishonesty, should we assess it, do you think, by reference to what the defendant thinks, Emma thinks, and she says, in my view, all reasonable people would say this is honest, or should we assess it by reference to what the jury think, or what reasonable people would think, what we call an external objective standard? So is it a matter for the defendant to say, I don't think it's dishonest, or should it be for an external objective standard?
I would say definitely an external objective, because someone who's not involved directly in the scenario, or especially she's going to want to defend herself, and therefore she's not to be charged, and therefore she doesn't want to be convicted of a crime. But anyone who's external and therefore has an objective stance, like the jury should, and they should have an objective point of view.
So it should be for the jury to say, we think this is dishonest or honest. Absolutely, but it's a jury decision. Okay, on that point then, I'm going to give you the answer in a minute, but I want to have a vote on this, just by a show of hands. Who first thinks Emma is dishonest and should be convicted of cheating and punished? Who thinks she should be convicted? Okay, we're not going to count her, but okay. Who thinks she's acted honestly and should not be convicted? Ooh, that's pretty close. I think that is 50-50. So some of you are right, some of you are wrong, according to the Supreme Court. Now, as I say, this was decided last year, essentially this case, and the Supreme Court said a number of things. They certainly said that the act of saying you are superstitious when you're not and manipulating the dealer was dishonest. But they also said that even if Emma had not done that, if she had just relied on her exceptional memory skills, that would be dishonest as well. Emma is guilty of cheating. Dishonesty, they said, in light of what you've just said, is an objective test. It's not what for you as an individual to define it, it's for the jury to define it. In that case, it was actually for all the judges to define it. They said it was dishonest. And actually, you up there, when you said that she was changing the rules of gambling and gambling is a game of chance, that is exactly what the Supreme Court said. That if you rely on any skill to subvert the game of chance, then you are dishonest. So what's the lesson? I think the main lesson is don't go gambling, because it could really work out against you. Now, we could then spend ages now, if we were in a supervision, talking about the implications of this. Are we happy with the definition of dishonesty, etc.? But you can see how a relatively simple case raises some big issues particularly, is it appropriate to prosecute somebody, convict them and punish them when in this room we were really split 50-50? Any of you could have been on the jury. And if I was in the position of Emma in the dock, it would really depend on luck as to which of you were on my jury. So that raises all sorts of things about jury trial as well. Okay, I'm going to leave that one there and hand over for a different one.
Thank you. Right, I think I know how to press this. Yes, a much shorter problem, which I'll start by reading through, and then we'll talk about. So, Mr. and Mrs. Smith, who have 6 children already, decide that they do not want any more children, and so Mr. Smith decides to have a vasectomy, so a male sterilisation operation. Unfortunately, the vasectomy operation is performed incompetently by Dr. Lanham and does not work. Sure enough, Mrs. Smith becomes pregnant again shortly afterwards and gives birth to a baby girl. I'm going to add an adjective there, gives birth to a healthy baby girl. Can Mrs. Smith and her husband, there was some question this morning about whether this was a new husband, so let's make it simple. The same Mr. Smith and Mrs. Smith recover damages from Dr. Lanham. So, first thing to notice is that we're not talking about whether anybody can be punished, prosecuted, convicted of an offence or anything like that. We're into the civil law where people tend to sue each other for some sort of civil remedy, and in this case, financial compensation. So I didn't do this morning, but I'll start with a show of hands, because that seems to work rather well. Put your hand up if you think the couple should be able to recover compensation. Okay, and put your hand up if you think they shouldn't. Again, I would say maybe slightly under, so more of you think they should than shouldn't. So that's quite interesting. I'll tell you in due course what the law says. This is based on a real case. Facts have changed slightly, but based on a real case from a few years ago. So the first thing to notice is we'll assume that this is an NHS medical treatment. Can anybody think why, as a matter of just sort of legal rules, that might make a difference? What if it was a private doctor? Yeah.
Because by being NHS, we're assuming it's free, and if it was paid, then there'd be a contract.
Good, that's absolutely right. So there's no contracts when you use the NHS, so we're not into the territory of the law of contract. I doubt that would make any difference to the answer, actually. But nonetheless, we need to anchor ourselves in the right bit of law. So we're in the law of tort, and more specifically, the tort of negligence. Now, what I thought I'd do is give you, this is a very unusual, very controversial set of facts for invoking the law of negligence. I thought if I very quickly give you a simple set of facts, a straightforward set of facts, we'll see if this differs or resembles the standard set of facts. So a standard set of facts might be that I'm driving incompetently. Indeed, I'm driving very negligently. I'm driving at 90 miles an hour in a 30 mile an hour zone, not paying attention. I mount the pavement and I knock you over and your leg is broken and you suffer terrible pain and suffering and you can't work for several weeks, so you lose wages. You can no longer play football, whatever it might be that you like to do. So in that situation, you have a fairly standard claim in negligence. Actually, in the real world, it would all be pursued via insurance and the courts would never get involved. But underlying that is liability insurance, is liability in the tort of negligence. So let's just see how that simple set of facts maps onto what you need to show in order to sue for negligence. And these elements are rather artificial for aid of sort of parceling things up into manageable intellectual ideas. But so to do that, you start by asking whether the driver owed the victim a duty of care. And the answer is very straightforwardly yes. Drivers owe pedestrians a duty of care. We won't go into any further what that might mean. Was the duty breached? Did the driver drive negligently? Answer, well, yes, 90 miles an hour in a 30 mile an hour zone, definitely. And then did that breach of the duty, did that negligence cause damage? We've got two ideas in one there. The idea of causation, well, I think we can be pretty certain that legs don't spontaneously shatter if they're not hit by a car. So you can be pretty certain that it was the defendant's negligent driving that caused the broken leg, and a broken leg is fairly obviously damage for the purposes of the law of negligence. Personal injury is fairly standard damage. Okay, so can anyone think of any respects in which that pattern perhaps doesn't quite work in the case of Mr. and Mrs. Smith? Yeah.
Does it kind of partly come down to whether the couple were aware of the failure? Because if they weren't aware that they failed, then, or sorry, if they were aware, then they, it hadn't been successful, then the damage wasn't necessarily caused by his negligence, it was caused by them.
So that's a good point, actually. If they'd been told, oops, because actually let's not get, I am being filmed. When someone has a vasectomy, they do a test some weeks later to see if it's worked. And if they were told, oops, it hasn't worked, but they sort of ignored that and carried on and the baby was conceived, then I think there'd be quite a convincing case that it was their failure to take sensible precautions that caused the birth. But let's assume that they'd been told it worked fine, and therefore, if it wasn't for the negligence of the doctor, this baby wouldn't have been conceived. But that's a good point. Yeah.
I don't think the doctor had responsibility on them having children or not, because the operation was to sterilise, right?
Yep.
Or was it to stop them from having children? So the doctor would have responsibility on that.
So what is the point of sterilising someone if not to stop them having children? It's a good point, actually, because, in fact, it's a very English approach to this, which is to say, not to put words into your mouth, but I think you were saying, well, there might be a bit of a problem with whether this is the right sort of duty here. Doctors owe a duty not to harm their patients, but they may not assume responsibility for the size of their family or something. So if he'd caused, terrible pain to the victim and, damaged his men's bits forever after, really skirting close to then sure, that would be the sort of scenario caught by a duty of care. This is very English reasoning, and it really troubles me that we say when you're doing something, you owe a duty not to do cause this sort of harm, but not a duty not to cause another sort of harm, because it means that you can't advise the defendant what duties they owed until time has passed and you know what harm they've caused. So it's not really meaningful. But therein lies a very big debate. But there's another bit missing, isn't there? Or another bit that's problematic in the analysis. Let's go over into the court. Yeah. Young lady, yes.
The idea of damage.
Yeah.
So whereas actually is the baby girl damaged.
Absolutely. So we're faced with not a broken leg or, a broken spine or something, but the birth of a healthy baby girl. Now, it doesn't immediately look like damage. It looks like a blessing to lots of people. I bet the parents in the room are thinking, the thing about children, I've got 3, is that they're flipping expensive. And actually, in the law of negligence, we do sometimes, not very often, but we do sometimes allow people to sue when the only damage they've suffered is purely financial, just the loss of money. So if I give you, negligent investment advice and you rely on my advice and lose lots of money, then you probably can sue in negligence and for breach of contract as well, concurrently. But, so it's not. This is what the claimants were arguing. We've got a botched operation followed by financial loss. Why not? Now, it's at this point that the House of Lords, because before it was called the Supreme Court, it's called the House of Lords, the most senior court, agonised about that outcome. So you have a set of rules, duty, breach, causation, and so on. But they're not in a vacuum or in a dusty book. They have to be nuanced and contextualised in the real world. And it's not just a simple matter of saying this looks like a duty, this looks like a breach. Because this was the first time this sort of claim had ever reached the senior courts. They had to decide whether to extend that precedent to this new set of facts or whether to distinguish it. And in doing that, they can only really consider values and ideas that are something a little apart from just the application of strict legal principles. And they said things like this. It used to be, in the 19th century, the man on the Clapham omnibus. the test of how the reasonable person would perceive things. That's extraordinarily out of date, it's gendered, it's, you know, the Clapham Omnibus doesn't exist. So they talked about the reasonable person on the London Underground. So although it's not gendered anymore, it's still rather southeast London biased. But anyway, they said this hypothetical arbiter of reasonableness would be appalled at the idea that you could treat the birth of a healthy child as damage. They pointed to things like the fact that the health service is publicly funded. You know, this money that went to this couple would be taken away from maybe 20 couples who were being denied IVF treatment. All sorts of ethical issues and so on. So the outcome for the couple in the actual case that this is based on was rather a compromise, as usual, in that Mrs. Smith was given damages for the pain and suffering, look what I'm patting my tummy, the pain and suffering of having to endure a pregnancy that she didn't want, but they were denied damages for the costs of bringing up a healthy child, which was the overwhelming, probably 95% of the damages that they were claiming. Now, then what happened? This is what's so wonderful about the law, because all human life is there. And you have this precedent. Just a few years later, another failed sterilisation, another botched sterilisation. I mean, I'm using very pejorative language, and we could have a discussion about the appropriateness of fault-based liability on the NHS. I mean, I have views about this not being appropriate, but let's go with the flow. The law of negligence applies to the NHS. What came along a few years later was a case where a female sterilisation operation was performed negligently, and the woman gave birth to a child that had severe disabilities. And it's fascinating facts, because the botching of the sterilisation operation didn't damage an embryo or anything like that. It wasn't that direct a connection. It's just that by coincidence, the baby that happened to be conceived, the next one, you know, after the failed operation, happened to have severe disabilities. This case gets to the Court of Appeal. Then what do? They have to decide. They're bound by the precedent in the previous case. This language of bondage is quite interesting. They're bound by it, which means they have to follow it. But they only have to follow it if it's exactly the same facts as the case that comes up. Of course, identical facts don't occur. What normally happens is that the new case that comes along has subtly different facts from the precedent. And the new court has to decide whether the difference doesn't really matter and therefore we apply the precedent, or whether the difference is actually crucial and we therefore distinguish the precedent. In other words, go the other way or carve out a new exception or something like that. And this put the Court of Appeal in one of the most difficult dilemmas you can imagine. Because on the one hand, what message does it send to disabled people if our law says a healthy child is a blessing, but a disabled child, that's damage. That's like death or personal injury. That's like a broken leg. That's an appalling or you might regard it as an appalling ethical comment on the value and dignity of the lives of disabled people. On the other hand, this was a very serious disability that caused the young mother to have a really significantly difficult life. And the court was compassionate and could see that she really was, in a sense, damaged. The mother was. And she loved the child dearly, as did the people in the previous case. So they cobbled together a compromise, which was to say, we're bound by the precedent that she can't recover damages for the costs of bringing up a child. But if there are any additional costs that flow from the child having a disability, she can get those. Extremely irrational, because, as I said before, the negligence didn't directly cause the disability. It just caused the child to exist. Either it exists or it doesn't. But also, this is where I reveal my family circumstance, which is that I've got 3 children, one of whom has Down syndrome. And she's the cheapest of the three. And it's an awful thing to say, and the mothers and the parents in the room will understand. But she's unlikely to go to university, whereas the other two will/do, and therefore, just for that alone, is unlikely to cost as much. So it's a strange decision, but it raises so many wonderful kind of almost moral, ethical, political questions about the allocation of scarce resources within a publicly funded health service, about how we value babies, children, disabled people, and so on. I'll just throw in one last argument that the health service tried in this first problem. I'm conscious I've gone off supervision mode and into lecture mode. I do apologise, but sometimes it's the only thing you can do. But anyway, the health service, or the Dr. Lanham's barristers, shall we say, tried to argue that Mrs. Smith, when she discovered she was pregnant, ought to have had an abortion. And it's a bit like your point, only rather more brutal, which is that she knew she was pregnant, she found out she was pregnant presumably fairly early on, and she decided to keep this seventh baby. She caused all her losses. It was her unreasonable decision to proceed with the pregnancy. Eclipses the responsibility of Dr. Lanham. She causes the loss. We could have a whole lecture on what cause means in the law, but happily, I think, the court, although she lost on other grounds, they threw out that argument. How can it possibly be unreasonable to decide to proceed, so utterly unreasonable that the buck passes to you, to decide to proceed with the life of your own baby? And indeed, it would have been difficult to argue that that fell within the legal grounds for termination, because the mother's health and the baby's health were unaffected. So, but you see what sort of a simple set of facts gives rise to. You only have to think about it for more than 30 seconds to see how rich the law is, how it's not about pulling off a Victorian book from the shelf and learning what's in it. That's just the start, in a way. You can look up what the law says. Then you've got to apply it and think about it and consider, the principles and the values that underpin it. So, time for for a total change of direction. Oh, hang on, I've gone too far. There we are. Whereas that was based on a real case, very simple set of facts based on a real case. This is an exam question that I wrote a few years ago that somehow in the last few months has come back into my mind, what with royal weddings and so on. So I thought I'd give it to you. So let's just read through quickly. I know we haven't got very long, but this is much more actually the sort of thing you might have to answer in an exam. The royal wedding of His Royal Highness Prince Rupert to Lady Sophia Sterling was due to take place on the 1st of August. On the 5th of March, the department store Harrods contracted. I know, this is the sort of, passes as a joke in a law exam, but anyway. The department store Harrods contracted with Royal Staffordshire Pottery Limited, RSP, so they made a contract at that point for the supply of 1,000 limited edition hand-painted royal wedding plates featuring the image of the royal couple and the date of the marriage for a total contract price of £50,000, that's £50 per plate, of which £10,000 was paid on contracting, i.e. then, on the 5th of March, the balance payable on delivery of all the plates, 1,000 plates. Delivery was to be no later than the 1st of May. On the 1st of April, here we go, Buckingham Palace announced that the couple had broken off their engagement and the wedding would not go ahead. So the following day, on the 2nd of April, Harrods told RSP that in the circumstances it regarded the contract as null and void and demanded the return of its £10,000 prepayment. RSP ignored this communication, completed the remaining plates and delivered them to Harrods on the 3rd of May. Notice the slight timing problem at the end. And the question is RSP entitled to claim the balance of the price? So they're owed £40,000 for these plates. So this is a problem squarely within the law of contract. Now, if you were doing this, not in the loony and rather artificial world that we create in exams or in supervision, but in the real world, maybe some of the accompanying adults will have experienced something like this in their lives. But Any thoughts what you'd want to do first, before you gave any advice on the law at all? Yeah?
Maybe allow RSPs to keep the 10,000 prepayment, but not actually allow them to receive the 40,000.
So that's a solution that some people might think is a fair compromise. But RSP want their 40,000 and Herod wants its 10,000 back. So we've got to know what the law says, who wins. You know, that a compromise might well be the very best solution, but it's not the way the law operates. There's a right answer. But how do you work out what that right answer is? Yeah?
Perhaps the first thing to do would be to find out if there's a written or a verbal contract.
Good. Yeah. So, and there's clearly a contract, which is almost certainly written. Why would you need to know whether there's a contract?
Because then you know if there's acceptance on an offer. Acceptance.
So there's certainly a contract, all that stuff, offer and acceptance and so on. But why does that matter? Why? Yeah.
Like, just with any caveats with the contract to do with, changes to the wedding.
Good, yeah. So almost invariably in the real world, facts like this wouldn't be a problem because the parties would have had the sense when they agreed the terms of their contract back in March to include terms or provisions that specify what happens if, and actually over the years parties get more and more and more sophisticated about thinking what might go wrong. Terrorist attack, hurricanes, war, outbreak, cancellations of weddings, all sorts of things can go wrong that the parties don't expect to go wrong, but if they do, they need to know what happens. So if they've had any sense at all, they would have put in a provision that deals with this. In which case the answer lies in the contract, not really in the law, the general law. But let's assume that they were rather blasé companies, and they just entered into a very short, one-page contract, or even oral, even verbal, over the phone, which made no mention whatsoever of this. At this point, the contractual regime, and we always start with the contract because freedom of contract is what the law is based on, what the parties have agreed. But if they've agreed nothing, then the question is, should the law step in? That sounds like the law is a person, but should the law say, in these circumstances, that contract just becomes null and void? Ought that to be a common outcome, or should it be an exceptional outcome? Should there be any role for that sort of intervention by the law? Any thoughts? Yeah?
Yeah, I think it should depends on whether there has been any damage or cost involved by the manufacturer. If there has been some cost, then they should recognize the cost and give them some compensation. They cannot say, well, it's finished.
So the law will want to look at what the remedy ought to be at the end of the story and whether there's any compensation owed one way or the other. But before they can do that, we've got to decide what the legal position actually is with this contract. It's very difficult for you to guess. Oh, yeah, let's...
Even if you say that the fact that the wedding was cancelled doesn't make the contract null and void, the fact that the place was delivered 2 days after part of the contract was explicitly stated would then make it null and void.
So you've spotted the fact that right at the end of this problem is a twist, which is that they don't comply with the time provision in the contract. So, and that will cause a problem, although not necessarily to make the contract null and void. It's more likely to be regarded as a breach of contract. The contract still exists, but it's been breached. But we only get to that point if the contract still exists in order to be breached. So the first question I think to ask is, should the law just let these parties escape from this contract completely because of the cancellation of the wedding? And this is the point where I say the whole point of making contracts is to get certainty now about what's going to happen in the future. Allocate the risk of things happening in the future. I make this contract on the 5th of March because I want plates in April. The other party makes a contract on the 5th of March because they want money on the, whatever it is, of what was it, 1st of May. So the law needs to be extremely wary about letting parties off their agreement, but extremely wary about saying this contract has become null and void. Very occasionally the law does it, And it's a doctrine that goes by the wonderful name of frustration, doctrine of frustration. Very, very exceptionally, the courts will say, there's been such an extraordinary external change in circumstances that we regard this contract as being frustrated. It's become just sort of, it's just, whoa, it just doesn't work anymore. But that is really rare. So if I made a contract to hire you my hall for an event, but unfortunately by the time the date for performance comes round, there's been a what do you call this? A sinkhole has opened up and the hall has actually disappeared, doesn't exist anymore. It's then impossible to rent it out, or it's burnt down or something. In other words, it's become impossible to perform the contract. The court might say, the law might say that contract is frustrated and therefore null and void. But look at these facts. Has it become impossible to perform this contract? Not at all. Has it become more onerous, more difficult? No. It's just, for one party, pointless, lost its point. But notice, for one party only, hasn't lost its point for RSP. That's how they make their money. They make plates and they sell them to shops. So for RSP, it's very much retained its point. For Herod's, it's lost its point. So I would venture to suggest that this is that the court wouldn't regard this contract as null and void, despite the cancellation of the wedding. Bad luck, Herod's. You should have put a provision in the contract saying, you know, we don't have to pay if the wedding's called off. So because the contract is still fully effective, it's there, it's not been frustrated, it's there exactly as it always was, then Herod's communication that effectively sticks two fingers up to this contract and says we don't want the plates anymore is itself a breach of contract. RSP, I mean, the law is very complicated, it's not very terribly interesting, but RSP, you might have expected them at that point to say, okay, we hear what you say, you don't want the plates anymore, but we're going to sue you for damages or something of that kind. They'd be entitled to do that. But instead, they ignored the communication and produced the plates. And actually, that's pretty rare. That doesn't happen very often. Normally, you need the cooperation of the other party to perform your obligations. But here, very unusually, they don't. So your point is absolutely right. If they delivered them on the 1st of May, as the contract stipulated, then they could have sued for the price. They could have claimed the price. It adds another 3 hours worth of lecture and, well, at least an hour's worth of lecture to discuss what would happen by virtue of their late delivery. But I'll give you the reason now why I set this question. And the reason I set this question goes back into the depths of legal history. I don't know if any of you know your early 20th century British history, but a very trivial bit of it is. But King Edward VII, Queen Victoria's son, was going to be crowned in June, I think it was 1901 or 1902, I think. And he developed appendicitis, and his coronation was postponed. And this affected a lot of contracts. And in particular, some homeowners, people who had flats that overlooked Pall Mall, where the coronation procession was going to go past, they had, very unusually, because they were just ordinary homeowners, made contracts with people who wanted to rent that flat, just even a room in the flat, like their front room, for several hours that afternoon, overlooking the coronation procession. When the king's coronation was postponed, 99% of the flat owners in that position just made a reasonable adjustment and just agreed with the person that wanted to sit in the lounge or the living room to postpone the contract till the day of the rearranged coronation. But Mr. whatever he was, and I bet he was a lawyer, flipping bet he was a lawyer, rich lawyer who owned a flat, tried to say to the bloke that had rented the room, well, you agreed to rent my front room for £50 on the afternoon of the 2nd of June. Nothing to stop you doing that. There's nothing going past the window, just an empty street, but hey, £50, please. And the chap said, what are you talking about? This contract's null and void. I mean, it's obviously dependent on the coronation happening. Very, very exceptionally, the court held that contract was frustrated, even though it wasn't impossible, wasn't onerous or difficult to perform, it was just pointless. But I think the difference here is, on that occasion, the coronation case, it was pointless for both of them. The owner of the flat would never have let some stranger come and sit there if it wasn't for the passing by of the coronation. Whereas, you know, RSP make their money making plates for people, whether the plates are ultimately wanted or no longer wanted. But I'll tell you, I'll finish by saying, like most of my contract law colleagues, in a wicked way that's almost certainly treasonous or treacherous or whatever, we were secretly hoping that Harry and Meghan would call off their wedding just before, and there'd be all these souvenirs, and there'd be people that had booked rooms, and the thing would occur again at the beginning of the 21st century. But happily for everybody, that didn't happen. But it makes a very nice contract question. But again, you can see, you know, this is not just dry, dusty financial stuff. This is quite fun, and it's quite real, and I hope it's given you a taste, at least, that it might be some quite enjoyable ideas if you study law. Anyway, we have a couple of closing...
Yeah, so we won't have time for any more of the problems, so you can take those away and look at those problems in your own time. There are two final things I want to say. The first is, some of you may have come on this open day thinking, I'm not sure whether law's for me, I'm not sure whether Cambridge is for me. How do I know if law and Cambridge are right for me? Well, if you like these sorts of questions and thinking about the issues and the law in this sort of way, and if you've enjoyed this sort of discussion, then that's probably the best test that law and the way we teach law at Cambridge is right for you. Secondly, and I apologise, well, I don't apologise for what I'm about to say, you might still be saying, oh, is law the right subject for me? Is there something I could read that might help me to answer that subject? Well, the answer is yes, there is. There's a book, there are various books, but there's one particular book called What About Law? Studying Law at University, which both of us contributed to. And a few, so you can see what it looks like. So I'm sorry for telling you about this book. We try and sell as many copies as we can. But it was written for people like you who are trying to find out what law is like at university, and we would commend it to you to provide an answer to that. And hopefully, when you read that book, you will see that the study of law is really interesting. It is wide-ranging, and I hope you can tell from our enthusiasm for law that it's a brilliant subject to study. Thank you very much.